State of Michigan versus Jessica Marie Carl.
On OV 17, I would ask the court to consider that being 5 points instead of 10. The 5 points being for the offender failed to show the degree of care that a person of ordinary prudence in a similar situation would have shown.
The difference between 5 and 10. 10 is for wanton or reckless disregard for life, property of another person versus the failure to show the ordinary care and a prudence in a situation. The court's going to deny that challenge. I find that the conduct was wanton and reckless. She couldn't even tell if there was a stop sign. At one time may have said there neither party had a stop sign, but the defendant had a stop sign. Plus she was in a fight on the phone with their 16-year-old boyfriend. And plus there was a comment that he said she made that she was going to end it all. So the court denies that challenge. Next one.
Yes, Your Honor. The other part was scoring. We'd ask the court to consider not scoring OV 19. We do realize this was a no contest case, so I'll limit this a bit. But my client does not recall asking anyone to lie.
Okay. There were statements in the police report. I did review that. In fact, I went over the scoring myself today over the lunch hour. There were statements made in the police report that she told a boyfriend to lie about how much alcohol she had. She also told police officers that it had been about an hour and a half. However, boyfriend and his mother said that she had been drinking just before she left. She also said she only had one, but they said she had two. Therefore, the court finds that she was attempting to make false statements.
First paragraph where it does mention the boyfriend's age that Your Honor just mentioned, we don't necessarily think that's relevant. We know that this will follow her throughout her time in MDOC, including when she applies for parole. We ask for that, the age part to be removed.
The court's going to deny that. It's a factual allegation. It's a true factual allegation. And it's also, I think, made relevant by the written statement submitted on behalf of the defendant in her mitigation report about her relationship with her husband, and whether it was rocky, whether they're going to be together, stay together. I think it's important because I'll also note in People's Exhibit number 1, which the court referenced, and taking the no contest plea, there were transcripts of the telephone calls between she and the 16-year-old. I think it's relevant. Thank you. All right, Ms. Carey, I anticipate hearing from victims. Is that right?
Yes,
Okay.
several. My dad and I were kindred spirits. We shared an affinity for music, cute pets, and commiserating over things like property taxes and yard work. My dad, besides being everything a great parent embodies, was also becoming a true friend of mine. The way parents and children can sometimes become great friends as they become older together with much time. My dad was a gentle soul too. The night he was killed, he was going to pick up birdseed to feed his birds so they wouldn't starve during the cold snap we were having. He was making sure the car was secure and ready to go for an upcoming trip my mom was about to take with their daughter-in-law and grandkids. And he was likely looking forward to getting home to visit with my brother, who was in town helping him stock up on firewood. My mom had just made meatloaf that night in anticipation of his return, and it was still warm when she and my brother started getting worried that he wasn't answering his calls, and eventually left to go out to look for him. That night, my dad was taken from me prematurely. That night, I lost the joy of not having that one person you default to call to share a funny story with. I lost a confidant. I lost the bravest person I know who would fight for me and always protect me. I have been left permanently asking these questions. How did this happen on the streets of my small and seemingly safe hometown? How did this happen to someone who has driven these streets safely for the past 40 plus years? How did this happen to the one person who always worried about my safety, who I relied upon to always protect me? How did this happen to my dad? Who else will this inevitably happen to? Thank you.
So thank you for the opportunity to speak today, Your Honor. It seems impossible to explain the impact that this crime has had on my family and on me, but I will try. Especially difficult for me to deal with has been the sudden and violent nature of my dad's death. He was such a dependent and careful man, and the way he died was the opposite. We were not able to see his body because of the violent accident. We were not able to say goodbye. We were not able to honor his choice to be laid out in a casket because of the violent crash. I must think how I drive and how I live in a world. 2 months after the crash, my oldest of 3 children turned 16 and got her lessons. As you can imagine, what would have been an exciting day was overshadowed by my dad's violent death due to a reckless driver. Each day I work to keep my anxiety in check as my daughter drives away from our house on her way to practice or to school. I drive myself each day. I have to overcome my own fears about what could happen, how it would feel to be broadsided by another car running a stop sign at a high speed. When I first heard about the accident, I thought the other driver had made a horrible mistake, and I felt bad for her. After learning more, however, it's clear that she was reckless and has a history of disregarding laws meant to keep people safe. I ask you to please exceed the recommended sentence so that your own family does not have to experience these kind of senseless loss.
I'd like to start by thanking everyone who testified today for coming in to say what they had to say for the impacts. I do think that's appropriate to say that. I do want the court to know that I have seen the weight of that on my client while she's been sitting here listening to it. She's very aware, and I know it doesn't take away from anyone's pain, but she does feel this is important. This is a no contest plea, obviously, so I'm going to have to limit a lot of what I allocute for obvious reasons. But I do thank our office social workers for doing the mitigation report. I do believe they did a well job, as they always do. I do thank the people who submitted letters of support for my client. I did look those over, and I know that they do wish her the best as well. I know her, at least at one point, her son and a few other people were in the courtroom. They may have stepped out because he's young and making some sound. Oh, well, if they're still there. But trying to show respect to the court.
It's okay.
But I would ask the court to factor in the word accident was used multiple times per day, and that's a legitimate way to describe it. We're not trying to take away from the harm or the legality of it, but this was something that was an accident. My client did not intend to harm anyone. And I stress all those qualifiers. For what it is worth, a lot of times, even in district court cases, I'll just use the phrase, but for the grace of God, they could have been in the exact same situation. A lot of people don't realize that the prescription drugs, those are still drugs. There's not some magic wand that just because the doctor put his initials on a piece of paper, make it the different chemical compound. A lot of people don't realize that when they're below the legal limit, like my client was, that interacting with those other chemicals can't lead to the results that we see here, these tragic situations. And I do hope some people are watching this and learning preemptively from this and can take something away from it. I do hope some productive things do come from this tragedy. I would ask the court to consider sentencing on the lower end of the guidelines. She's realistic. She knows she's not going home anytime soon. She knows she's going to prison. When I was reading the PSI with her, rightfully so, the author did write in there that she is technically eligible for boot camp if the sentence was 3 years or less. I realize the guidelines go significantly above that, but I would ask the court just to factor that in.
I haven't seen a courtroom this full for sentencing, I think, ever. So I think that speaks volumes as to the support they have and the type of person that Mr. Collins was and what was taken from them. February 7th of this year, the defendant ended the life of Mr. Collins. It was avoidable. It was unnecessary. It was violent. And it was life-changing for his family. It was not an accident and mistake. It was a sudden and violent crash for Mr. College because the defendant consumed alcohol on top of taking pills, including a sedative. She then got in her vehicle, got on the phone with her 16-year-old boyfriend and was driving down the road and blew through that stop sign at 63 miles an hour. This is just before 6 p.m. We're all from here. We know what a busy, well-traveled, dangerous area that is. And reading the mitigation report and the attached letters provided by the defense, many things stood out to me. In that report, the defense writes, the defendant came from an unstable, unsafe, and abusive environment at the hands of her mom, stepdad, and dad, and that there were mental health issues and violence and drugs. Yet when she talks about her support system, it is made up of many of those same people, without any indication that they have received help or rehabilitation or changed in any way. It states she has 6 children. The PSI has reported she has given up her rights and or did not have custody of 5 of them, some of whom are adults now. The defense report mentions a diagnoses, including post-traumatic stress, anxiety, ADHD, borderline personality, manic depression, and a mood disorder. It mentions them, but does not provide any support to show that she has actually been diagnosed with those conditions, nor did she provide any support that I saw to the Department of Corrections for those alleged conditions, nor does it provide or state what she's done to address those, other than while she's been in jail on a limited basis. And in the PSI, where it talks about treatment, that section is blank. Defense asks that the defendant not be seen as the product of her trauma, but as a person who survived and is trying to rise above. I would argue that her record suggests otherwise. She has not been trying to rise above. She has 18 criminal entries on her criminal history beginning in 2003. Her behavior prior to February 7th, on February 7th, and since February 7th indicate the opposite. She was here visiting her 16-year-old boyfriend, even though she had a 2-year-old son and a husband at home. She was drinking, taking medication, arguing with her 16-year-old boyfriend, and then she decided to get behind the wheel. One of the letters in support of the defendant said they were proud of her for not leaving the scene of the accident. I'd like to point out, as it's stated in the police report, she couldn't leave. She was trapped in the car. She hit Mr. Kalish's car with so much force. They were both trapped inside of their vehicles. Another of the letters in support asks that you not judge her based on her past. Well, I would argue we do get to consider her history. We do get to consider the 18 convictions questioned by the police. Her 16-year-old boyfriend reported at the time of the accident, the defendant told him she only had 1 drink. Told him to report that she only had 1 drink, but he said he wanted to be honest and reported that she had 2 tall cans of Twisted Tea, and he crushed them when she asked him to. We get to look at her actions after February 7th. So at least until July 7th of this year, she was still in contact with the 16-year-old boyfriend who is now 17. On July 7th, after her pre-sentence interview, she called him, excited that her sentencing guidelines were lower than she expected, believing she would be out in about 3 years. The 17-year-old was not impressed, and she told him he would be begging her to come back to him, that nobody would love him like she would. Yet in the PSI, she told the Department of Corrections she believed she and her husband would be able to work things out. The 17-year-old asked her why she kept running back to him. She said her good heart made her fall in love with him. He was still not swayed. And then the defendant told the 17-year-old that he was just as much at fault for this crash as she was, because he was on the phone with her and because she left his house. She told him she talked to her lawyer and he could be charged too. And then she yells at him for snitching her out when he talked to the police. One day after the crash, defendant had a phone call with a 16-year-old boyfriend, and she learned that Mr. Kalish was 74 years old. And she said in that recorded phone call, that's why he ended up dying. And excuse my language, this is not me speaking. She said, that's why he ended up dying, because he was so fucking old. And then she continues, maybe if it was a younger person, they would have lived and I wouldn't fucking be in here. I would have gotten out already. I would just add an OWI and sat for 24 hours. That is the type of person that the defendant is. And while the mitigation report tries to paint a picture of someone overcoming a rough life, her own words and her own actions show us who she is. She is only concerned about herself. Criminal history goes back to 2003 and includes 16 prior misdemeanor convictions and 2 prior felony convictions. She has out-of-state convictions, including domestic violence, common law uttering, intoxicated and disruptive, breaking and entering with force. In Michigan, her convictions include retail fraud 3rd degree, 2 retail fraud 2nd degrees, trespass, domestic violence, malicious use of a telecommunication device, for which she was unsuccessfully discharged from probation. Then has 2 domestic violence seconds convictions, 1 with an unsuccessful discharge from probation. 2017, she was convicted of resisting and obstructing a police officer and domestic violence. She was placed on probation and then had probation revoked and a prison sentence was imposed. Also in 2017, she received a malicious destruction of property while on probation. In 2019, possession of methamphetamine, and in 2021, operating while visibly impaired. In 2022, retail fraud 2nd, and then in 2025, here we are. Your Honor, given the circumstances of this case, the irreversible damage caused by defendant's behavior, defendant's continued poor behavior, her history, the wishes of Mr. Kalish's family, the people respectfully request the court to find grounds to exceed the guidelines and sentence defendant to 15 years in prison, which is 2/3 of the maximum. Thank you.
So I respect the fact that the law allows an individual in this instance to enter a no contest plea. Whether or not people like it, if some people want to hear an apology, the law says that you have that right. Therefore, I can't take anything away from it. I won't. Is there anything you wish to say at this time?
I would like to address a couple of things with the prosecutor. Would that be all right?
Yes, you may, ma'am.
First of all, my husband is actually in the courtroom and we have been working things out. He is here to support me and he's right there, the black in the back right there.
I saw him. He's the one that had a little kidder.
Yes, that's my 2-year-old son. Probation office, all my records for my mental disorders and all the treatment I had, they failed to, get the information. I was there with my lawyer when I did it. I gave him Gresham Integrated, which I've worked with successful. I was on disability for my mental disorders.
I'm going to tell you that inside the police report, which I used to take the no contest plea, there was a list of your MAPS, which is your medical record,
Yes, sir.
and it talks about your medications. I know you were seeing a family nurse practitioner down in Ithaca and another doctor. I can't remember his name, but I looked it up and I see that you had prescribed medication for certain matters.
Yep, and Gresham Integrated Network is the mental health down there. And that's where I've been seen, and I've seen them all since I got out of prison the last time. I've taken very well care of myself for my mental disorders. I went to DBT for my borderline. I've done DBT twice. And I've seen a psychiatrist and psychologist. And the whole time I was in the methadone clinic, I seen a therapist there. It was required once a month. And the whole time I went there, and I did drug testing. And with my methamphetamine charge, I wanted to bring up the fact that I did OCC when I got arrested. I never tested positive, and I did OCC, successfully completed that, and I never tested positive. So it was, bless you. I wanted to bring that up, reiterate that. So I've been clean off drugs for a long time. The only thing that I was doing was my prescription medication, which as you see by the lab report, I took them as prescribed. And that day I mean, I know it's a no contest, but I wasn't using them. And I can't really go into things, but there's a whole family here. And I just want to say I'm not from this area and I don't know the roads. And I don't want them to think because I have a black and white criminal history that I'm a bad person because I haven't gotten in trouble for over 4 years. Since I got married, I've been doing good. I have a son and we had a rocky time and that's what ended me up here. And I've been trying to work things out with my husband, but I never intended to go out that day and actually hurt somebody. I'm not a bad person. Just because people have criminal histories and done things bad in their life and come from bad backgrounds doesn't mean they're bad people. And I feel like if someone wants to paint me as a bad person, you know, people grow up bad. People have bad backgrounds, but it doesn't mean that's how they have to be. I can't sit here and explain to someone who's doing a mitigation report. We'd have been in there for 5 days, Your Honor, if I had to explain to them the help that my mother got or somebody else. I don't have all that time.
Mr. Hartel and his office provided the mitigation report, and their social worker did a very thorough job explaining all that. So
Yeah.
while it's not all spoken out loud, I
Well,
have read that.
Prosecutor did say that I put in anybody else getting help or anybody else. My mom's a devout Christian now and she has changed and it wasn't her at the hands that hurt me. It was certain men, but I can't sit here and go in detail over a phone and approve everything in my life. Didn't really have time to do all that. Kind of hard to keep my
Well,
brain in
again,
focus, Your Honor.
Mr. Hartel and his office covered quite a bit of that. I did read it, so I understand.
But I just prepared a short statement, but I honestly, in my heart, I feel, no words can probably settle the hearts of, I don't know how to pronounce their last name, but, the victim's family. Cause I just, yeah. But it says, Judge, I've had a lot of time to think about everything. And I can't go into too much detail because of my no contest plea. But I read the 2 victim impact statements that came with my packet. And if I could, I would definitely undo what happened on February 7th. And I would take his place. And I can't really say much, but there's a lot that goes on in my head that I can't really talk about. But I wish that it never happened. And I had actually said to a sergeant the other day, I said, do you think the family would want me dead? And he's like, because you said, even if you tell them that you're sorry, they're not going to believe it anyway. Because if it was my family, they wouldn't care anything. He wouldn't care anyway. So I don't think any apology I give them that they're going to believe me because they already have their mindset on how they feel about me.
In this instance, Ms. Carl had multiple items in her substance, in her body. She had a little bit of alcohol, about a 0.40, but mixed with it, she had opiates, or opioids, which was the hydrocodone. She had at least 2, from what I could see, 2 Schedule 4 controlled substances, in addition to hydrocodone, which is Schedule 2. And I do often hear people say, but it's on prescription. So, just like saying, well, alcohol is legal, but it doesn't mean you can drive if you're drunk. Well, with controlled substances, it's in your system, and when you start mixing alcohol with it, it's a recipe for an auto accident. I know this intersection very well. I grew up 1.5 miles away. Below the speed limit, she was exceeding the speed limit, which is another reason why I noted that it's wanton and reckless, because I know that there was no braking. until she collided with the car. That's because it was more than just what an ordinary person might make a mistake. It was wanton and reckless. And then when she was asked by law enforcement, she said that she didn't have the stop sign and maybe the other guy did or maybe he did. And she was in an argument with her boyfriend. When I look at some of this stuff, it's clear she's had a difficult life and she's had a difficult time fixing it, even though she's got married and has a kid. She's been dating this young kid for a couple months. And I know the young kid knew about it and so did the husband because they were recording phone calls and I read all the transcripts of those phone calls. They were in People's Exhibit number 1. Oh, I know she was telling David to go talk to Justin and Justin would come back or messages through David. You know, in fact, David, she did say something to the effect of beforehand, according to David, I'm just going to end it all. And then he had to tell her, well, you've got to think about your son. And there was something he said right after that that was quoted in the report. It said, quote, because that normally works to calm her down and remind her she has something to live for. That word normally should be the word that stuck out. This 16-year-old kid knew enough from dating her for just a brief period of time that she was already mentally not doing well because he would normally, which means more than once, have to remind her that she should have something to live for. So I think when she left that house that evening, she was not in the right mind, and she was definitely off the deep end and under the influences of alcohol and controlled substances. And I'll tell you, there's the one thing that struck me the most. And I gotta wonder, because I hear people make stupid comments all the time, and I often think it's because they can't deal with what they've just done, or it's the self-defensiveness. But I'm going to tell you, it rings very well in my head. Miss Carey gave a quote. She did. I already had written down that quote. But it's not just once. She actually said it a couple times over the next couple of days in talking to David, the 16-year-old kid who she professed her love to, and they both said that they would wait until she got out. Well, maybe if it was a younger person, they would have lived and I wouldn't effing be in here. I would have gotten out already. I would have just had an OWI and sat 24 hours and sobered up. Next time. That's why he didn't live, because he was so old. And then on those phone calls, repetitively, Ms. Carl expressed her worry. And one of the things she worried about when talking to young David is how she was being portrayed on TV in the news. David would tell her that, well, it was, they're saying it's a DUI. And then she would yell or get in the phone and say, well, that's effing untrue. Those cops are effing liars. Because it wasn't just for alcohol. The action, and then even at the scene, there was a statement that she didn't have enough to drink, so therefore nothing should really happen to her. Whenever the judge is asked to exceed the guidelines in this case are 58 to 142 months. Pursuant to MCL 769.34, subsection 3, the court cannot use things that are already taken into consideration in scoring the guidelines. So I can't consider the death. That is already included. I can't consider her prior convictions. Those are already used to calculate the guidelines. The conduct afterward, if he had only been younger, he may have lived, and I wouldn't be in this mess. Doesn't go over well with this court. She asked her boyfriend to lie, but that was already taken into consideration by offense variable number 19. There are other things. This defendant has not only had prior convictions, but in getting those prior convictions, she has also racked up probation violations. The legislature gives us the guidelines, and the guidelines are repetitively told that they are not mandatory, but there are other statutes that talk about how we're supposed to use them. But at the same time, it says where the characteristic has been given inadequate or disproportionate weight. It's that word, inadequate. I cannot fathom how the legislature puts value on a life and says that 50 points is adequate. I don't think it's adequate. Consider it because the law has already told me I can't. Therefore, I won't use that as adequate, but I will say that the guidelines don't take into consider probation violations and more. You know, I sometimes in a sentencing case, I might get nothing. I may not get victim impact statements. Today, I got some really heartfelt impact statements. Impact statements are taken into consideration when establishing the sentence. Tears are not taken into consideration when establishing the sentencing guidelines. The pain by multiple people, the impacts that ripple through a community. I do not understand how that can be adequately scored. Because I don't think they can. Regardless, I've got multiple issues here which I can consider, and I do. The sentence of the court is as follows. And I'm going to make this announcement, and I don't think I need to say this, but everybody please be calm toward one another, toward Miss Carl's family, to the friends and the family here. Thank you. The court sentences the defendant as follows. $68 state minimum fee, $130 crime victim right fund fee, a $300 court cost. I need to get that restitution. Restitution in the amount of $5,185.13. The court sentences the defendant to the following sentence. Again, I've covered my justifications, and I find this sentence to be reasonable and proportionate. I'm going to exceed the guidelines by a bit based upon what I've established, but I'm also very considerate of any appellate issues. Therefore, the court sentences the defendant to a period in the Michigan Department of Corrections of 160 to 270 months with 174 days of credit. Again, that is outside the guidelines. I've covered my issues for my justification, exceeding the guidelines pursuant to the court statute that I referenced earlier. Madam Prosecutor, this is your Exhibit 1. Mr. Hartel, you're going to take Ms. Carl, 2 copies of one document. This document tells you, Ms. Carl, that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you complete the bottom half and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Again, folks, I had to say a lot of things because I wanted to cover every side. Please know the court feels for both sets, both parties. Nothing I can say can bring it back or undo it. The only thing I can say is God bless you all.